Okay, so let's go over contracts again. We started this last week, but this is I want to clear some of this stuff off my computer, man. It's getting kind of slow. So a contract has been defined as an agreement to do or refrain from doing a particular thing upon a sufficient consideration. Now, the reason that I want to go over contracts again, and I want to go through again, this is from American Jurisprudence, the second edition, under contracts, subsection 1. Okay, you can look it up right there, American Jurisprudence, second edition, and I got it here from Fine Law. Okay, so this is reference material, and this is basically the definitions of a contract. Now, if you're here and you're looking at some of these videos, it's because you're either having issues with the corporation that starts with the state of, or the city of, or the department of, that is using you as a surety for that all capitalized name. If you don't know what the all capitalized name is, you should probably go back a few videos. But yeah, man, there's supposed to be a contract. Contract makes the law, okay? These guys are operating a for-profit corporation. You're not in their jurisdiction. However, that all capitalized name is in their jurisdiction and is their property, okay? But they're trying to make you the surety for it. So if this helps, that's why we're here, man. And again, you can go in here and you can cut and paste some of this stuff if you want. You can go to Fine Law, okay, reference.finelaw.com, and you can look this stuff up and you can put it in your paperwork and you can ask them when you go in there. Of course, the first thing you want to say is, I am the holder in due course. I am here as a third-party intervener making a special appearance as an authorized representative for the defendant. And there's some other stuff too, but you want to make sure that it's Rule 24 in the Rules of Civil Procedure, and that's appearing specially, because you are not the defendant. You are not an all capitalized name. You are not a legal fiction. And they have a contract with that all cap. They don't have a contract with you. But once again, they are using you as the surety. You are giving energy. You are giving life. You are giving your labor for this all capitalized name, which is what you use to operate out in public. And once you realize that there's public and private, and that there's a way to go in there if you're having issues with these departments and these state ofs. There's a remedy, okay? And part of the remedy is that there has to be a contract, okay? Because once again, contract makes the law. So similarly, a contract has been defined as an agreement, an obligation, or legal tie by which a party binds itself, okay? So the straw man is bound to them, okay? And if you look at your paperwork, it's all capitalized. They're speaking to that thing. They are a bankrupt corporation, and they need your assistance. They need your credit on the private side because they're bankrupt, and they produce nothing, and they have nothing, and they do nothing, okay? So they're asking for your help, okay? I know that's hard to wrap your head around, but they're actually trying to ask for your help in a very, very ignorant way. So also, a contract has been defined as a private, voluntary allocation by which two or more parties distribute specific entitlements and obligations. A contract is an agreement between two or more parties that creates an obligation that are legally, once again, legally, okay, there's legal and there's legally enforceable by the contracting parties, okay? Contract is an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law. A contract is an agreement between two or more parties whereby obligations are created, modified, or extinguished. Wouldn't that be nice to go in there and say, hey, where's the contract? Okay, yeah, I didn't agree to this, so it's now null and void. Goodbye. Wouldn't that be nice? Okay, so let's go to subsection 18. This is the formation of contracts. Okay, the elements of a valid contract are parties competent to contract, a proper and lawful subject matter, consideration, that's very important, that's your terms and conditions, and that's the, hey, I'll give you 2 cheeseburgers for $1. And you say, you know what, actually, why don't you give me 3 for $1 and throw in a Coke for another 50 cents, okay? That's consideration. That's back and forth, terms and conditions. Okay, you give me $2, I'll give you 50 cents back, and I'll give you 3 cheeseburgers, blah, 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 right? Mutuality of agreement or assent, that's both of you agreeing on the terms, and mutuality of the obligation, okay? So you're going to give me 3 cheeseburgers and a soda, and I'm going to give you some of these worthless Federal Reserve notes, right? Okay, so those are the proper, lawful consideration, terms and conditions of a contract. Here's the offer. Acceptance. In strict compliance with the terms of the offer, a meeting of the minds. That's another important thing right there. A meeting of the minds. Each party's consent to the terms. Consent. Okay? Very important. And execution and delivery of the contract with the intent that it be mutual and binding. Okay? Well, in order for a contract to be binding, there has to be 2 consenting parties. Offer, acceptance, consideration, capacity to contract, okay? Now, again, we went through this. These 4, 5, 6s down here at the bottom, okay, is where they're getting all this, okay? Geisel versus Dowd, Bank of the Ozarks versus Walker, okay? Gallagher versus Woodbury, okay? So when you see these little numbers, so it basically says the same thing, but it says it in different terms, okay? So a contract is made at the time the last act necessary to its formation is done, in addition to where the last act necessary to complete the contract is performed. The contract is also said to be completed at the place where the offerer is accepted. Okay? While the existence of a contract is a question of fact, whether a certain or undisputed state of facts establishes a contract is a question of law for the court. Well, once again, you might have to take this to court. And in my opinion, you don't have any rights in those Article 3 courts, Article 1 courts. They're all corporate, and they're all commercial, and it's all equity, and they're all, outside your jurisdiction. So they're not talking to you, they're talking to that all capitalized name. So formation of contracts, assent, offer, acceptance, assent, necessity of mutual assent, and intend to be bound. There must be mutual assent or a meeting of the minds at the same time on all the essential elements or terms to form a binding contract. Once again, man, child support. Do you have a contract? Did you sign an agreement? Okay. Did you become the surety for that all capitalized name? Because they'd really like to get some federal funding. All they need is your name and a social. Okay. That's all they need. In some jurisdictions, mutual assent involves the issues of an intent to be bound by the agreement, as well as definiteness, of terms. In determining if the parties had a mutual assent or meeting of the minds necessary to reach agreement, the courts apply an objective theory of intent, whereby one party's intention is deemed to be that meaning a reasonable person in the position of the other contracting party would ascribe to the first party's manifestations of assent. In making that determination, the circumstances surrounding the making of the contract, such as correspondence and discussions, are relevant in deciding if there was a mutual assent to an agreement. Okay? That might be important right there. Okay? When they brought you in and you were arguing and telling them, hey, dude, I'm not on welfare. All that stuff doesn't apply to me, right? Well, that might be something you can cut and paste into your paperwork, right? Cut that and paste that and, right click on it and, just copy that and put that over in your paperwork and tell them, hey, dude, there has to be a meeting of the minds. There has to be mutual assent to an agreement. And one more thing before we go any farther. If an ambiguity which means basically a question. It's basically something that doesn't, add up, doesn't fit in the whole. If an ambiguity renders the alleged agreement too indefinite, even after the consideration of extrinsic evidence for the court to determine the party's intent, the contract cannot be enforced due to the absence of any discernible meeting of the minds. Okay? Also, a failure to agree on or even discuss an essential term of the contract may indicate that mutual assent is lacking. Okay? That sounds like that's also important. Okay? If they don't even want to discuss it, if those magistrates, if those friends of the court won't even allow you to discuss, then that probably means that they don't have standing and they don't have authority. Okay, let's go to contracts, subsection 101, contracts 101. Formation, consideration, necessity, definitions, and nature. Utilizing a legal definition of contract, no contract exists without sufficient consideration. Consideration may be a benefit to the promisor or a detriment to the promisee. Okay, so 85% of the time, from what I've read, this is my opinion. Don't take this, as, God's law, but drawer and promisor and obligor and everything with this OR is usually you, okay? And the E's are usually them, okay? So you have a promisor and you have a promisee. It may take the form of a right, an interest, or profit accruing to one party. Gee, that sounds like them, doesn't it? They're trying to get a little profit there. Or from some forbearance, detriment, or responsibility given, suffered, yeah, there's our word again, or undertaken by the other. There's that word, undertaking. It may also consist of the creation, modification, child support modification, right? Or destruction of a legal relation. There is consideration for a contract if the promisee, being induced by the agreement, does anything legal that he or she is not bound to do, or refrains from doing anything that he or she has a right to do. It is sufficient that something valuable flows from the promisee. So what are they giving you? What is the consideration? What compensation are they giving you for stealing your money and using it for housing and welfare and food stamps? Or that he or she suffers some prejudice or inconvenience, and that the agreement is the inducement to the transaction. Okay, so what does that mean, to induce? That means to force somebody. Okay, they're forcing you by all their legal mumbo jumbo and legalese to give the state a bunch of money so that they can use it to offset their welfare expenditures. Okay, so let's look at the formation of contracts. Okay, definiteness and certainty. To be enforceable, an agreement must be definite and certain as to its terms and requirements, or contain provisions which are capable in themselves of being reduced to certainty. Okay? Even if there are some formal imperfections in the contract, to have a valid contract, all terms should be definitely agreed upon. And the failure to agree to even one essential term means there is no agreement to be enforced. Okay? We got that? Okay? So if you disagree with one thing in your divorce, it is unenforceable. The test for the enforceability of an agreement is whether both parties have manifested an intention to be bound by its terms, and whether the terms are sufficiently definite to be specifically enforced. To be binding, a contract must generally be sufficiently definite to permit the determination of a breach and remedies. Okay? So in all contract law, there's got to be a remedy. So in case they breach the contract, or in case you breach the contract. However, it is not required that all terms of agreement by precisely specified, and the presence of undefined or unspecified terms will not necessarily preclude the formation of a binding contract. An agreement to the essential terms of a contract does not mean that the terms must be set out in the plainest language, and it does not follow that parties must share identical subjective opinions as to the meaning of those terms. Okay? No enforceable contract comes into being when parties leave a material term for future negotiations, creating a mere agreement to agree. Generally, an agreement to agree is unenforceable as its terms are so indefinite that it fails to show a mutual intent to create an enforceable obligation. All right, now we get into the good stuff. Contract, subsection 197. Mistake, fraud, misrepresentation, duress, and undue influence. Gee, does that sound like a child support case or what? In general, a mistake can be defined as a belief that is not in accord with the facts, and it has been specified that the term mistake refers to the party's beliefs at the time the contract is made, not the party's acts. However, mistake in a contract has also been defined as an unintentional act or omission arising from ignorance, surprise, or misplaced confidence, which is so substantial and fundamental as to defeat the object of the parties. Okay? Let's go on. Okay, let's go to 216. Legality of contracts. In general, parties are free to contract and see it as they see fit, right? Because that's in the Constitution. Your ability hits Hale versus Henkel. We've showed that to you several times. Hale versus Henkel. It's from 1902, 1907 or something, United States Supreme Court. A citizen's right to contract is unlimited, and that also means that your right to not contract is also unlimited. So parties are free to contract as they see fit on any terms regarding the subject matter in which they have an interest. Well, is your child, are you got an interest in your kids? You sure do. How about your property? How about your house that they just gave to her? How about your money? How about your compensation for labor? How about your car? How about your paycheck? Do you have an interest in that stuff? Is that your property? I believe it is. So in general, parties are free to contract, provided that the contract does not impose obligations that are contrary to statute, public policy, or an established rule of the common law. That's where you guys fit. Thus, the law recognizes and protects a broad freedom of contract, and competent persons ordinarily have the utmost liberty of contracting. Okay, now let's stop real quick too. They're talking about competent persons. Okay, and when you go into a courtroom and you have a lawyer who is representing you, you are not competent to deal with your own commercial affairs. And that means that you're an imbecile. And that means that you are a idiot. Okay? You are retarded. Sorry, I'm using that word that's socially incorrect nowadays, but that's what it says in the law books. If you cannot present yourself and you are not competent to handle your own affairs and you need a liar to stand next to you and admit jurisdiction, you are not competent to deal with your own private affairs. So that's where they're talking about right there. And may incorporate in their agreements any provisions that are not illegal or violative of public policy. The law looks with favor upon the making of contracts between competent parties upon valid consideration and for lawful purposes. And the courts generally enforce private agreements, okay, which is what I'm doing with my administrative process, between parties. In fact, out of respect for the freedom to contract, courts are hesitant to interfere with purely private agreements. Good, because I don't want you trying to interfere. I want you to give me summary judgment. That's it. Just look at my process and tell me I did it right or I did it wrong. Indeed, given the strong commitment to the principle of contractual freedom, courts should hesitate to infer from a statutory clause granting specific permission to contract under certain circumstances a general prohibition against contracting under other circumstances. Okay? Subsection 323. General rules of construction. So construction, putting together a contract. In reviewing a contract, courts may engage in interpretation or construction of the contractual terms. Contract interpretation involves ascertaining the meaning of contractual words. Construction refers to deciding their legal effect. Specifically, when interpreting a contract, the ultimate goal is to ascertain and give effect to the intent of the parties as reasonably manifested by the language of their written agreement. And when construing agreements involving clear and unambiguous terms, a court need only examine the writing itself to give effect to the parties' understanding. Where a contract dispute centers on the meaning of certain terms, courts engage in the process of interpretation rather than construction. Okay, and that's where you could get hurt, because when they're doing this, construing, okay, that's basically an opinion, okay, and then this process of interpretation, that's also the court's interpretation. So all contracts should have definitions attached, just like my security agreement and just like most other contracts. They, because like, once again, they change the words, they change the rules. Here's a perfect example: the word person, right? We all know if you look up the definition of person in a legal dictionary, it says it's a corporation. Okay, subsection 496. A modification of a contract is a change in one or more aspects of it that introduces new elements into the details or cancels some of them, but leaves the general purpose and effect of the contract intact. Modification of a contract normally occurs when the parties agree to the parties, not one party, agrees to alter a contractual provision or to include additional obligations, while leaving intact the overall nature and obligation of the original agreement. Parties may modify or waive their rights under a contract and embed new terms. Did you know that? You can waive your rights and probably not even know it. Also, parties may alter any terms of an existing contract by entering into a subsequent contract, which means a new contract. And the contract, as modified, becomes a new contract between the parties, and the meaning to be given the subsequent agreements depends on the intention of the parties. So I'm just having a flash right here. So what if you get something in the mail from child support and you sent them a counterclaim, counteroffer, and you wrote up a little one-page, one-paragraph that said something to the effect of, hey, I received your presentment that says I owe you $400 a month. So, under my right to contract with you, we're going to say no to your offer. And I'm going to tell you that I'm going to give you $50 a month from here on out. And if you don't respond to this letter within 30 days, you agree to pay me $1,000 for my time and suffering. I wonder if that would work. Because you would be modifying the contract and you would be counteroffering their presentment. Just one of those things, just thinking on my toes, Okay, so subsection 513, modification, extinguishment, renewal, rescission, termination, Generally, a contract may be canceled only under its own terms or through mutual agreement. Contracts have the effect of law for the parties and may be dissolved only through the consent of the parties or on the grounds provided by law, okay, which would be, threat, duress, coercion, all that. A contract may be discharged by performance in accordance with its terms or by the expiration of the time during which it is to remain operative. In addition, there are several other methods of discharging contracts, including rescission, right, which is when you rescind your signature, or by virtue of a contractual provision, rescission from original invalidity, okay, so it's invalid from the beginning because there's no meeting of the minds, there's no consideration, right, or rescission for failure of consideration. Well, that's what I just said right there, consideration of you didn't get the terms and conditions, or a material breach or default. Parties to a valid contract may rescind or abandon it or substitute another in its place, which is what I just said. So send them a counteroffer. Or by conduct inconsistent with the continued existence of the original contract, a stop, right? There's a stop, there's a stopple, themselves from asserting any right thereunder. So, if you create an estoppel because you have ignored my counteroffer, your silence is acquiescence. Your silence is now the new contract. Okay, 598, performance or breach, sufficiency of performance. Okay, although substantial performance of a contract subject to the right of recoupment with respect to variations between the actual and stipulated performance is the general test for determining the adequacy of performance of a contract, and literal compliance is not required except with regard to express conditions. It is clear that a person cannot be compelled to take and use one thing when he or she bargained for another and declines to receive the substitute tendered. Therefore, what constitutes full performance generally depends upon the construction of the contract in light of the surrounding circumstances. For instance, a finding that the work performed had been generally successful in satisfying contract requirements may be sufficient. Similarly, evidence that a software developer was to deliver a beta version of the program to the publisher for blah, 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 even though it was containing bugs, strict full performance may of course be waived. Okay. So they're talking about other stuff. An express condition of a contract must be literally performed in order for the relevant obligation to arise, while a plaintiff's performance of the contractual promises must be merely substantial before it can recover for a defendant's breach. So I'm thinking out loud again. So in my case, I let child support go for a lot of years because I was ignorant of the law. And I thought all that money was going to Nicholas, my son. And then I found out, a long time later that it wasn't. And after speaking to the ex and finding out that they were taking $450 a check and she was only getting 180 hit or miss, that's what pissed me off and sent me down this road. So if you are under the assumption that that money is going to your child, and it's not, then that would be a breach. That's just my, my 2 cents. Okay, this one's getting a little long. Subsection 623. We've got 4 more here, so deal with, just easy. Strict and full performance of a contract by one party may be waived by the other party, in which case there is, to the extent of the waiver, no right to damages for the failure to perform strictly or fully. This is in accord with general principle that either party to a contract may waive any of the provisions made for his or her benefit. Did you waive benefits? Moreover, if the parties mutually adopt a mode of performing their contract differing from its strict terms, or during the course of the performance, they mutually relax those terms, neither party may claim that a breach occurred because the contract was not literally fulfilled. So I don't know if this is what I just read right there, but if the parties mutually adopt a mode of performance, okay, or performing their contract, differing from the strict terms that child support set up in your divorce, or during the course of the performance, they mutually relax those terms. In other words, you and her getting along. She said, you tell her, hey man, I'm hurting. I need to skip a payment. Yeah, he's fine. He's out of school right now. He doesn't need anything. Just give me the money next month so I can buy him some school clothes or whatever, right? Neither party can claim that a breach occurred because the contract was not literally fulfilled. So in other words, what I'm thinking out loud right now is this right here sounds like this would be your child support arrears. Okay, so if you guys, now of course I don't know your situation, but that sounds kind of like what happened with me, because there was a time when I wasn't working and I didn't have any income, and the state of Utah was not giving my ex money. So I didn't have an obligation to the state. Okay. Now, do I have an obligation to take care of my son? Well, of course I do. But, that's hard to do when you're in jail, you know. So just, again, thinking out loud. 632. One who agrees to do for a fixed sum a thing possible to be performed will not be excused or become entitled to additional compensation because unforeseen difficulties are encountered. So one who agrees to do. Okay, well, number one, I didn't agree to any of this. And I didn't agree to that fixed sum. Okay, so will not be excused. Well, you know what? I didn't agree anyway, so it doesn't matter. Non-performance of a valid contract is a breach unless the person charged shows some valid reason, like I'm sitting in jail and I'm not making money, which may excuse the non-performance. So let's say that you go to jail for a year. Do you still have to pay the state of whatever for the money that they didn't give to your girlfriend, that they're just making up on a piece of paper? Yep, sure do. And what does it say right here at the end? And the burden of doing so, which is what? Coming up with some valid reason, rests upon the person charged with the breach. You know what? They don't give a shit either way. They don't care. All right, we're in the home stretch. Performance of breach, excuses for non-performance, impossibility or impracticability of performance, impossibility of performance. For the purposes of extinguishing a promisor's liability, because a contractual promise becomes objectively impossible to perform, there are two kinds of impossibility: original and supervening. Original impossibility is impossibility of performance existing when the contract was made, so that the contract was to do something that was impossible from the outset. While supervening impossibility develops after the contract in question is formed and exists when the subject matter of the contract for which the parties bargained is no longer in existence or is no longer capable of being performed due to an unforeseen supervening act for which the promisor is not responsible. The reinstatement recognizes both original and supervening impossibility. Does that make sense? It's not your fault, man. They're making all this shit up. Subsection 669, performance breach, excuses, definition of breach, act or breach by adverse party. The word breach, as applied to contracts, is defined as a failure without legal excuse to perform any promise that forms a whole or part of a contract, including the refusal of a party to recognize the existence of the contract or a party's act that is inconsistent with its existence. A party who has brought about a breach of contract may not insist upon its performance, and thus a breach of contract caused solely by one party's behavior is generally excused as to the other party. However, a party is not automatically excused from performing in the future every time the other party breaches. Only where one party substantially breaches a contract does the other party to it have a defense and an excuse for non-performance. Okay, we made it. So I want you guys to know about this, and we're going to close this out. This is a summary. This is like a 2,000-page book, so there's a lot of stuff in here. But once again, if you go to Find Law, go to Legal Reference, go to American Jurisprudence, 2nd edition, Contract Summaries, and you can go down here, and there's a lot of stuff in here. But the one I wanted to show you is there's certain grounds of illegality, contract actions against ambassadors, there's contract aggregation of persons, particular kinds of property, and there's one right here that says contracts by persons in special relation to each other. See American Jurisprudence Agency, American Jurisprudence 2nd, divorce and separation, husband and wife, and parent and child. So that right there looks like something that we might want to look into. All right, you guys, I know that was a long one, but thanks for sticking around.